So, good afternoon and welcome to today's Lunch and Learn. I'm Ms. Burley, employment law solicitor, and I'm focusing today on the topic of ending employment. So, this is an important HR topic. I'm going to be focusing on the legal aspects. Of course, lots of other things we could discuss, but in half an hour, we're going to cover the legal basics. So, moving on to our first slide, just to show you the overview. So our legal overview today is going to focus on the legal basics, as I've said. We're going to have a quick quiz to see what your kind of test your understanding of some of these basics. We're going to think about redundancy essentials. We'll bust a few myths. We'll think about how you protect your business when you end employment, or if one of your employees decides to leave. And then we'll think about some of the financial and legal aspects that we haven't covered earlier. So on to the legal basics. So ways of ending employment. Well, of course, employment is a two-way thing. So we have employees might decide to leave, or we might be in a situation where we, as the employer, have to make a decision to terminate employment. And of course, the picture will look really different legally, depending on which of those scenarios we're in. Just to cover the different ways legally of ending employment. So resignation by the employee, with or without notice. I'll come on to what without notice might mean potentially for legal liability. Termination by the employer, with or without notice. And with notice would usually apply if we are ending employment for anything other than gross misconduct. And if we're in a situation where there is gross misconduct and a disciplinary dismissal, then we'd be calling that a summary dismissal, ending without notice or pay in lieu of notice. In all other scenarios, termination by an employer must be done with notice. So there are, and there are two other ways which termination can happen. Those would be a mutually agreed termination, very unusual for that to take place without a settlement agreement being in place, or frustration of the contract. And that's a very, very rare situation in which an event takes place which literally, by law, operates to frustrate the employment relationship. And the only example I've ever come across of that is sickness absence that goes on for years and years and years and never gets resolved. So very, very rare indeed. So two things to have in mind, and why ending employment for employers is tricky, and sometimes if it's a resignation as well. We have two frameworks we have to think about. The statutory framework of employment rights under the Employment Rights Act predominantly, and the contractual picture. So employment is a contractual relationship, usually governed by a written contract of employment, not always. But within that employment contract, whatever is agreed, whether that's verbal or in writing, that's the basis of the relationship. And on termination, the usual thing we're thinking about in terms of termination and how it's done legally for the contractual aspects, it's notice. So if as an employer you terminate somebody's employment summarily without notice, unless there is a situation involving gross misconduct, then that would be tantamount to a wrongful dismissal. So usually employment contracts are terminated with notice. And notice in employment would either be statutory minimum, or if there is a contractual notice period that's longer, then that contractual notice period would apply. Most contracts of employment are based on a longer period of notice than statutory. Some are in line with statutory minimum, but the statutory minimum must be observed unless we're in a gross misconduct summary dismissal scenario. So I'm going to think a little bit about some of those statutory rights as we move forward through this session. But the first one, and the most obvious one, is unfair dismissal. So that is the right of any employee with over 2 years currently continuous employment to claim unfair dismissal if their employment has been terminated by their employer. In other words, and the statute deals with this, a dismissal is a termination expressly done by the employer. So in any other situation, if the employee leaves goes AWOL, doesn't turn up for work, says, I've had enough, um, in any of those other situations, that won't be a dismissal by the employer because we're thinking about expressly done dismissals. A letter saying you are fired, words saying we don't want you here anymore, or language of dismissal. Um, so in that scenario, if you dismiss an employee with over 2 years service, they have protection against an unfair dismissal. They have to exercise the right, of course, and bring that claim through the employment tribunal. But if they do, the burden will be on you as the employer to demonstrate two things: that you have a potentially fair reason for dismissing, and that you have followed a fair and reasonable process to arrive at that decision. And those two basic elements are key to any unfair dismissal claim, no matter what what the type of dismissal is. There are 5 potentially fair reasons. They are conduct, capability, redundancy, illegality, or some other substantial reason. But don't be fooled by that last one. Some other substantial reason doesn't mean a bucket that you can put a dismissal in if you can't find another reason. It's not meant for that purpose. I will be covering unfair dismissal on my next Lunch and Learn. I'll be delving deeper into unfair dismissal. So if you want to understand more about those reasons for dismissal and how they operate, then do turn up at my next month's Lunch and Learn. Tricky issues I want to cover because I mentioned the 2-year rule and I said currently. The Employment Rights Bill is very slowly making its way through Parliament. It's not quite finished yet. When it is, that continuous employment requirement will come down. We're not sure yet whether it's going to be 9 months, 6 months, or no period of employment at all, day one. The headlines say day one. The Lords and the Commons are currently battling it out, whether it needs to be 6 months or 9 months. We shall see. But currently, until that law changes, we're still at 2 years. Now, the tricky issues here, pregnancy, health and safety, discrimination and whistleblowing, are reasons why. Those are areas where, if dismissed for those reasons, an employee does not need 2 years service to bring the claim for unfair dismissal. They can claim automatic unfair dismissal. If they prove to a tribunal that that is the reason they've been sacked, then the 2-year rule won't apply. So you need to be really wary of those areas if your employee is under 2 years continuous employment. So I'm going to move on quickly to our quiz, and I'm not expecting anyone to answer out loud. I'm just going to rattle through these questions. Which of these is considered to be a potentially fair reason for dismissal in the UK? Is it A, B, C, or D? And just give you time to think about that. What is the maximum compensatory award for unfair dismissal in the UK? Is it 25 grand, 50 grand? Is it 52 weeks pay? Is there no maximum limit? So just coming back to the first question, the potentially fair reasons on that slide, not A, not C, and not D. So it's poor job performance. That's the only area that would be a potentially fair reason. It would fall under the bucket of capability. The other areas would all be automatic unfair dismissal reasons if proved. The maximum compensatory award for unfair dismissal, there is a cap, so D is wrong. It's not as low as 25 or 50. It's either 52 weeks gross pay or the upper cap, which is currently set at 118 grand or thereabouts. It changes every year. So on to the next slide. A couple of other quiz questions. UK employees are protected from unfair dismissal from the first day of employment. Well, we know from what I've just said that that's not currently true. It might change in the future when the bill becomes law. We'll see whether it goes down to day one. Which of these is not a dismissal in legal terms? Mutually agreed termination, redundancy, employer giving notice, a pylon, which stands for payment in lieu of notice, or garden leave. Well, the last two are not types of dismissal. I'll come on to what they mean soon, but they're not actually dismissals. They're things that happen or have to be dealt with when somebody is leaving, but they're not dismissals in and of themselves. B and C, well, they are dismissals for statutory purposes. If an employer gives notice to terminate, we've already said that is a dismissal. Making someone redundant is a bit of a myth. Many employers think that redundancy is not a dismissal. It's a kinder way of terminating employment. But as I've said, looking at the statutory framework, it is a reason for dismissal. It's a potentially fair reason, but if done without fair process, it would be an unfair dismissal. So moving on to the next slide, I'm thinking now of protecting your business. So you've decided that you're giving notice to an employee and that notice is running its course, or you're in the scenario where your employee is leaving and they're serving out their notice. So what are the key things that you need to think about to protect your business from that leaving employee or from a risk of claims? Well, of course, I haven't covered it on this slide, but the first one is the process around the dismissal if you're terminating. The second issue, which I've not covered on this slide, and I will flag now, is even if your employee is resigning, if they do so in circumstances where they say, I'm not happy, I've had enough, this is all too much, this is the last straw, you have made my position untenable, and if they leave without notice, then you are at risk of what we call a constructive dismissal claim. I'm not saying it's a good claim, but it will depend on the context and what's happened and led up to that. But if an employee does resign in those circumstances, then it would be sensible to take legal advice on any steps you can take to try and rescue the situation or remedy or protect the business from the risk of that constructive unfair dismissal claim being brought or succeeding if it is brought. So, just moving aside those scenarios I've just painted for you, in any ordinary situation where somebody's leaving, well, you're not concerned about the risk of claims so much, but you want to protect your business assets, you need to think about confidentiality. Now, in a sense, it's a little bit late to think about confidentiality at the point where somebody's leaving because your starting point to protect the confidential information in your business is the contract of employment, the written contract. The reason for that is general duties of confidentiality during employment are different to, at law, are different to the confidentiality that your ex-employee owes you after they've left. The very limited confidentiality that's protected after they leave is trade secrets. And your business has a much wider scope of confidential information that you want to protect from being stolen, misused by an ex-employee than just trade secrets. Of course, in an innovative business that's creating new technology or processes or what have you, trade secrets are easy to think about. In a professional services context or a sales environment, trade secrets are less easy to identify. So you want that broader protection for all the other types of confidential information that you do not want to leak out or be stolen by your competitors or by an ex-employee who wants to set up their own competing business. So think about your contracts of employment, think about the confidential information that is protected in that written contract and make sure that it clearly identifies what you want to protect in your business and that it also says that the duty of confidentiality is owed during and after employment ends and it's forever. So that's the really important thing. When employment's coming to an end, you need to write to the departing employee and remind them of their contractual duties of confidentiality to the business. It's not enough to just assume that they remember what's in their contract. It's important to remind them. Equally so, restrictive covenants, which again you need to have in the contract that you enter into with your employee at the beginning of their employment. It will be too late to come at this when somebody's leaving. You can't introduce restrictive covenants when employment is terminating or afterwards. It's got to be at the beginning of the relationship or at some important point where there is a new bargain struck, maybe a promotion or an increase in pay or a widening of responsibilities attached to that increase in pay. Then you can introduce an updated contract and restrictive covenants in return for the bargain. Now, you need to think about reminding your ex-employee or the departing employee of those restricted covenants. You want to perhaps send them a further copy of the covenants. You want to remind them that they remain in place after employment has ended and the period of time and the types of covenant that they're bound by. In that way, you are bringing to their attention their ongoing obligations to your business and what might happen if they breach those covenants. Restrictive covenants are only for a time limited period, they won't last forever, but it's important that your employee realises that there are certain restrictions on what they can do, who they can go and work for, and what they can do when they're in that new employment going forward for that limited period of time. We mentioned garden leave and pylon earlier, so these are two things which can be deployed by you as the employer when somebody decides they're going to leave or when you're terminating employment, and they're relevant to the notice period. So, dealing firstly with garden leave, either you will have the contractual right to place somebody on garden leave in their contracted employment, or you will agree with them at the point that they're leaving that you want to place them on garden leave and they are happy for that to happen. Imposing garden leave can be a fundamental breach of contract if you haven't got that right written into the contract or you don't agree that with them. So just be careful about imposing garden leave if you haven't got it in your contract. And garden leave simply means that the employee is not required to attend work, whether that's remote working or in the office, at the usual place of work. They're not required and they're not allowed to be in contact with colleagues, customers, clients, suppliers, and that they remain at home and will work when you require them to work, if at all. Garden leave is an important protection for a business where a key employee is leaving and you want them to be outside of the business, not involved in the business during their notice period. Obviously, the longer the notice period, the longer the employee is going to be out of the business and the longer that period of protection. A payment in lieu of notice is a payment made to the employee reflecting the pay they would have received for working their notice. And the effect of that payment in lieu of notice is to bring employment to an immediate end. So if today I was going to say to Herman, we don't require your services anymore, thank you Herman for your time with Burley Law, you can leave today, I would still have to give notice, but I can pay Herman in lieu of that notice period. The notice period must be in line with the contract or statutory minimum, but the payment made must reflect the amount of pay for that period that would be due to Herman. But I can lawfully bring her employment to an end today by making that payment in lieu of notice instead of having her work the notice. Again, if you do not have the right contractually in your written contract of employment to make that payment in lieu of notice, that could be a wrongful dismissal. Frankly, it's not going to be worth anything to the employee because the damages for that wrongful dismissal would have to reflect the amount of notice they're entitled to. You'll have paid that anyway. So I'm less concerned about that not being written into your contract as long as you pay the right amount. And of course, the right amount will be their usual earnings. If they're on a salary, it's the amount of salary. If they're on variable earnings, it has to be looked at in terms of their average pay over the last, I think it's 12 weeks. If there's commission or bonus that's due, and pension contributions would also come into play in terms of what's owed in a pylon. And finally, I'm thinking about return of property. This is often the forgotten piece in the ending of employment relationships. Most commonly, it crops up in settlement agreements, but not often in just ordinary terminations. So obviously, if your employee has got keys, security passes, if they have a car, company car, if they have devices that belong to the business, those are obvious and you'll be thinking about them. What is less obvious sometimes is documents and information that might be stored on their personal devices. That might be their phone, a laptop, or a PC at home if they have worked remotely. So it's useful to look at your contract of employment and look at what is specified as their obligations on termination of employment, particularly about returning information, deleting information from personal devices, returning documents, and access to information. So passwords for apps, systems, accounts that they have in their possession that you will need. And obviously you'll be limiting or stopping their access to those systems, but you may need the passwords that they hold. So those are important things that often get forgotten on termination that you should be thinking about when notice is given on either side. And next, I'm going to move on to think about some of the other financial and legal aspects. I've mentioned settlement agreements along the way, and I just want to touch on why you might think about using a settlement agreement and how you might bring that about as the employer. So settlement agreements are not the usual way of ending employment. A settlement agreement is a contract that is allowable in law that must comply with certain statutory requirements. And it is one way in which legal claims, that's employment claims, and that means statutory employment claims, one way in which those claims can be lawfully settled against the employer. The other way that statutory employment claims can be settled is through ACAS and through what's called a COT3 agreement. But of course, that COT3 agreement can only come about if the employee or the employer have contacted ACAS and notified them of a potential employment dispute. A settlement agreement does not have to follow a dispute. It can be used, it can be negotiated before employment ends. It can be negotiated after employment ends. But it's often a mechanism that's used when employers are facing a situation where they realise an employee is either a bad fit for the business, or there is a performance concern that hasn't been addressed and is going to take quite a lot of time and aggravation and energy to address, and may not actually turn out well. Or if there is a tricky redundancy scenario that might involve some risk because, for example, the employee that you have identified for redundancy has a protected characteristic that might create the risk of a discrimination claim following if you make them redundant. So those are some typical scenarios where there might be legal risk or time involved for the business that you want to curtail a process. And the only way to enter into a conversation about a settlement agreement where there isn't an existing dispute with your employee, in other words, they haven't come to you saying, I'm being unfairly dismissed, I have a grievance about discrimination, I am blowing the whistle on unlawful wrongdoing. So there's no conversations happening that look like a legal dispute is developing about possible employment claims. So you're not in that scenario. You can't contact ACAS and say, right, we have an employment dispute, here are the potential claims. The employee is still ongoing employment. The only way to come at this lawfully is through what we call a protected conversation. And the law allows you as the employer to start a protected conversation. There are provisions in the Employment Rights Act that describe what is a protected conversation, how, or the requirements for a lawful protected conversation. And essentially, that looks like having a meeting with the employee, outlining the context of the conversation and why you're having the conversation with them, labelling it correctly as a conversation under the provisions of the Employment Rights Act, explaining the problem, why you think, what the issue is. So poor performance, redundancy coming down the line, possibly a reorganisation. There could be a number of things, but reasons why there might have to be a management process that might not end well for them, although it's too early to tell. And then leading into an alternative way forward, a settlement agreement which would see their employment come to an end, terms of which will be agreed, and an offer of a settlement of statutory claims that is a financial offer that is based on their employment coming to an end at a particular time, and is based on them waiving their statutory and contractual employment claims. So that's how it works. I wanted to cover that off because I think that's a really important piece that employers often don't understand. And I've seen many employers go into protected conversations, not having those elements in place and making a real mess of it. Termination payments I'm not going to major on, but if you do agree terms of a settlement agreement with an employee, that means their employment comes to an end, they will get certain payments. And those payments are usually referred to as ex gratia amounts. So that the ex gratia payment is one type of termination payment. Tax provisions will apply to that termination payment, which will make some of it taxable, some not, if it's over the tax-free threshold. And then other important element of pay on termination, two aspects. I haven't covered one of them here, but one is holiday pay, statutory holiday entitlement. If it hasn't been taken in full by the termination date, must be paid on termination. And the other element of pay, of course, is a payment in lieu of notice if you're exercising the right to make that. Very quickly, I want to touch on redundancy. I'm not going to go into a lot of detail here. We're running short of time, and this isn't a session on redundancy. But very quickly, just to cover a few basics off, because redundancy is often seen as not a dismissal, it's something else. Well, we know that that's not true, but it is a particular type of process that has to be dealt with slightly differently to conduct or capability dismissals. So what is a redundancy? Well, it's quite simply either a role is being eliminated or there are changes to a business that mean you've got less requirement for particular types of role. The legal requirements, quite frankly, are very slim, unless you're dealing with large-scale redundancies. That's 20 or more people. Legal requirements, you have to show a business case for redundancy. What are the business reasons? You have to consult with the employee, and you have to give them an opportunity to feedback, to take part. The consultation can't be one-way information giving; it has to be two-way. And then the payments required if once redundancy is confirmed, in addition to notice, a statutory redundancy payment, which is calculated as a week per year of completed employment. Of course, you can go beyond the statutory terms and offer enhanced redundancy, but that is not required by law. Communication and documentation are fundamentally important in any fair redundancy process, and the employee would have the right to be accompanied at the consultation meetings. So that's the bare essentials of redundancy. There are some peculiarities. If you're dealing with, obviously, people with protected characteristics, you need to be very mindful if you're selecting for redundancy that the protected characteristic isn't the reason or can't be seen to be the reason why they're selected. And pregnant employees and those returning from maternity leave have a protected period of 18 months where they're protected from redundancy, and they must be offered suitable alternative employment in priority to others. So those are protected species. And finally, the myths. Well, I think I've covered most of these already. 2 years, that's not correct. Resignation doesn't mean no liability. If somebody wants to claim constructive dismissal, resignation could still mean a dismissal if they want to challenge that they've been pushed into that by something that's been done to them or something that's not been done. So that's not true. Redundancy isn't always safe. It's a dismissal. You need to abide by the fairness requirements under the Employment Rights Act. Pile-on and garden leave are not interchangeable. They're two very different things. And the other myths on the slide there. Settlement agreements, they might fix everything. They don't. There are some specific claims that you can't use a settlement agreement for, but the majority of the obvious claims you can. A director being removed ends employment automatically. No, it doesn't. Directorships and employment are separate offices, if you like. Director is an office. Employment is separate. It's a separate status, and separate rights apply. References are optional. While there is no legal obligation to give a reference, we haven't touched on references here, and of course that would come probably after employment. They are not legally mandated, but if you do give a reference, then you have to abide by certain legal duties. So they're not completely optional. You can't say everything and anything in a reference. Restrictive covenants don't apply post-termination. Well, we know that they do, but we need to make sure that they're in the contract of employment from the get-go. That completes my talking for today. Some useful resources on the screen. ACAS is always a useful go-to. They have various guides on different types of dismissals and issues and processes. You can look at our YouTube for our previous Lunch and Learn webinars, and we will send out a free checklist for employers after the webinar. Our next Lunch and Learn session is on the 9th of October. I will be covering unfair dismissal, so drilling down a bit deeper into some of those fair reasons for dismissal and how to ensure that you're not caught out in tribunal. So I'm just going to skip over our starter bundle and our scale-up bundle that we offer to employers. If you want to have more details of those, just get in touch. And happy to take any questions now. And if there are no questions, I'm going to say thank you very much for joining me today. I hope that was a useful whistle-stop tour through ending employment. And thank you for your time. And I'll hopefully see you next time. Thank you.